goes to jail or who doesn't will no longer rely on how much money your mother has or your partner has or your grandmother has.
Illinois will become the first state to get rid of cash bail after a state Supreme Court ruling. Beginning in September this year, for most nonviolent offenses, defendants will be allowed out of jail until their trial. Supporters of this law, passed in the wake of the George Floyd murder, say that it will ensure people are treated fairly. But many in law enforcement say this will put enormous strain on their departments as they try to do their job. Joining me now to talk more about it, Jefferson County, Illinois Sheriff Jeff Bullard. Sheriff, thank you for being with us this morning as we understand the full effects on departments like yours of this new law going into effect. I want to play for folks at home, supporters of this new law that say it is progress for civil rights and why it was necessary.
The law of the land is going to be the Pretrial Fairness Act, and Illinois is going to make truly landmark civil rights history. We're not having this all happen, with the snap of the finger. There's intentionality.
And there will be people who have to navigate through some uncharted waters here, including you, Sheriff. You say this is a public safety issue. Explain to me your concerns.
Well, good morning, and thank you for having me on the show. It is a public safety issue. I've been in criminal justice for 32 years now, and when I started my career back in the early 90s, the policies in Jefferson County and the adult felony system and the juvenile system were more of a catch and release, kind of a revolving door. In any program, what I've seen that makes the potential for a revolving door system where arrestees are getting released prior to the officers even getting the paperwork done is that it makes a thriving area for dangerous repeat offenders. And that's what we saw happen in our community under different systems. And that I can see what I've heard from officials in other states, even in a previous interview I did with a mayor up in the Chicago suburbs, where Cook County has already been implementing these programs even before the Supreme Court ruled. And that is, in essence, what has happened. It's been a revolving door. So that's a thriving ground for dangerous repeat offenders, which is going to negatively affect your crime rate and the quality of lives of the people who live in those neighborhoods.
And does it also put law enforcement in danger if you potentially have to go track these people down for their court dates?
Yes. Every time someone misses a court date, that there's a failure to appear warrant that's issued, anytime they become a fugitive, it does increase the risk on the officers who are tasked to go apprehend them.
So the logistics of this could be pretty complicated. I think there's some things you probably don't know until you have to cross that bridge. But what are you doing right now? What's your department doing to prepare for this in September?
Well, we are working with the pretrial detention personnel. We're actually remodeling room in our courthouse for them to have office space. We're in constant communication. The Illinois Sheriff's Association helps us out with advice and recommendations based on which way the trends are going with this law. We've had 3 trailer bills on this. We are hoping that these trailer bills have taken out and lessened some of the real damaging parts of it, but time will tell on that. But the most important thing that we could say about this is that the U.S. Supreme Court has already ruled in the past that the courts cannot set excessive bail. So that's going to make a really good question for any criminal defendant that if they get arrested for a felony, that last year they would have had cash bail. And now a judge is telling them because of this law that they cannot have bail now. To me, that sounds like a pretty good argument by defense counsel to say that now their client is being hit with excessive bail. And another thing that is concerning is that dissenting Justice Overstreet, in his opinion, cited the fact that cash bail was specifically mentioned in the 2014 amendment to our state constitution, which means the only lawful way to change our Constitution is through the amendment process, not through passing a law and then judicial review by the Supreme Court to say that we can go ahead and do it. That whole process has been improper, and we appreciate Justice Overstreet's opinion on it.
What happens, Sheriff, to warrants that are assigned cash bond right now?
That they are still case-by-case basis with the judge to take a look at it. It's the policy that we are taking is that it falls on the defendant's counsel to petition to change it from a cash bond to a pretrial detention hearing.
Thank you for watching. Go to newsnationnow.com to find News Nation on your television provider. And don't forget to click the red subscribe button below to get more of News Nation's fact-driven, unbiased coverage.